All right, welcome. If you've got your sights set on the 2026 bar exam, you are in exactly the right place. Look, this isn't going to be just another dry lecture. Think of this as a strategic briefing on the law of evidence. We're here to strip away all the dense theory and focus on the practical, hardcore rules you absolutely need to master, not just to pass the exam, but to start thinking like a real trial lawyer.
Now, I know this statement sounds a little cynical, right? But it is the fundamental reality of how our court system works. You could have the most powerful, slam-dunk piece of truth in the world, but if you can't get it admitted into evidence, it is legally worthless. It just doesn't exist. So our entire focus today is going to be on mastering those rules of admission.
So, let's just get this out of the way. Stop thinking of the federal rules of evidence as some dusty old textbook. I want you to think of them as a chessboard. Every single piece of evidence you want to introduce, that's a strategic move, and it's governed by a very precise set of rules. Mastering these rules, well, that's how you checkmate your opponent.
So, here's our game plan. We're going to start with the two gates of relevance. That's the foundation for everything. Then we'll dive right into the propensity trap of character evidence. From there, we'll navigate the infamous hearsay labyrinth. And finally, we're going to master its most powerful exclusions. Sound good? Let's jump in. Okay, our first pillar, relevance. Before you even whisper the word hearsay or character, every single piece of evidence, without exception, has to pass through this initial gateway. This is the absolute starting point for any and every analysis you'll do. The first gate is Rule 401, which is all about logical relevance. And the key word here, the one I really want you to hear, is any. The bar for getting through this gate is incredibly low. Think of it like this. A single brick is not a wall, right? But it helps build the wall of your case. Your piece of evidence doesn't need to prove the whole thing. It just has to be one more brick. So, once you're through that easy first gate, you hit the second, much tougher one, Rule 403. Now, this is where the judge basically puts your evidence on a scale. On one side, you have its probative value. How useful is it? On the other side, you've got the danger of things like unfair prejudice. And here's the magic phrase you got to remember. The danger must substantially outweigh the value for it to get kicked out. It's a high bar to exclude evidence.
And here is your big strategic takeaway for the bar exam. When you're reading a fact pattern and you come across evidence that just feels like it's designed to make a jury angry or disgusted, I'm talking about gruesome photos or something really inflammatory, a giant red flag should go up in your brain. That is classic Rule 403 territory. It's an examiner's favorite trap.
All right, let's move on to character evidence. I call this the propensity trap, for a very good reason. It is without a doubt one of the most frequently tested and frankly most misunderstood areas on the entire exam. So let's disarm this thing right now.
So the general rule, Rule 404, sounds pretty simple. You cannot say, hey, this guy is a known liar, so he probably lied on the stand today. That is the forbidden propensity argument. Our system is built on the idea that we convict people for what they did in this specific case, not for who they are in general. But, and this is a huge but, that general rule is full of holes, and those holes are where the real strategy lies. I want you to burn this acronym into your brain, MIMIC. You can use evidence of prior bad acts to prove something specific, something other than propensity. Things like motive, intent, the absence of mistake, identity, or a common plan. Let me make this crystal clear with an example. Let's say a defendant is on trial for a bank robbery, where the thief used a really unique, bizarre method. Well, evidence that he pulled off a nearly identical robbery last year isn't being offered to show he's a bank robber. That's propensity, and it's forbidden. No, it's being offered to prove identity, to show that the person who used that unique method last time is probably the same person who used it this time. See the difference? That's a valid non-propensity purpose.
Okay, deep breaths, everyone. We're about to walk into the giant hearsay. Now, I know it feels like a twisting labyrinth, but I promise you, it all simplifies down to one single core concept. If you can master this one idea, you're going to be way ahead of the game.
This is it. These 6 words, this is the entire hinge that the whole hearsay rule swings on. An out-of-court statement is only hearsay if, and only if, it's being offered to prove the truth of the matter asserted. So, what does that actually mean?
From now on, whenever you see an out-of-court statement on the exam, I want you to stop and ask yourself one simple question. To make my point, do I need the jury to believe that the person who said this was actually telling the truth?
Check out this simple example. A witness gets on the stand and says, "John told me the sky was purple." Okay? If you're offering that statement to prove that the sky was in fact purple, well, then you care if John was telling the truth, right?
So that's hearsay. But what if you're offering the exact same statement to prove that John was hallucinating? Now, do you care if the sky was really purple? Nope, you don't care at all. You just care that he said it. Since you're not offering it for its truth, it's not hearsay. It's that simple.
All right, for our last piece here, let's talk about the real power plays, the hearsay exclusions. These are statements that look like hearsay, they smell like hearsay, they feel like hearsay, but the rules have specifically defined them as non-hearsay. These are your heavy hitters.
Now, two of the absolute biggest exclusions are right here. First, you've got statements by a party opponent. And this is as simple as it sounds. Basically, anything your opponent has ever said can be used against them in court. It's an incredibly broad and powerful tool. Second, there are certain prior statements made by a witness who is now on the stand. Things like a prior identification from a police lineup, those can come in as real substantive evidence. These are your go-to weapons.
So there you have it. We've walked through the gates of relevance, we've disarmed the propensity trap of character evidence, and we've decoded the core logic of hearsay. These rules, they aren't just an obstacle to memorize. They are the literal framework for your entire strategy. You've got the core briefing now. The only question left is, are you ready to play the game?
All right, welcome back to our deep dive into evidence for the NextGen Bar Exam. We're jumping right back in, getting into the really complex rules that, honestly, separate the masters from the memorizers. Okay, so here's our game plan. We're going to start by untangling those super complex hearsay exceptions. Then we'll get into the fun part, the art of attacking a witness's credibility. After that, we'll lock down the absolutely critical step of authenticating your evidence, and we'll wrap it all up by putting everything into a powerful strategic framework that you can apply to any evidence problem you see. So yeah, we're starting right in the deep end with the toughest hearsay exceptions. Look, this is where you really start to pull away from the pack. Master this stuff, and you are banking points while everyone else is just taking a wild guess. First up, we've got Rule 803. Think of this as the category of exceptions, where the law has just decided that the statement itself is so reliable, so inherently trustworthy, that it literally doesn't matter if the person who said it is available to come to court or not. This idea of inherent trustworthiness is everything. I mean, you can basically picture it as this shield of reliability. That shield is precisely why these statements get admitted. The context they were made in protects them from all the usual worries we have about hearsay. Now, you probably know the big ones, right? Present sense impression, excited utterance, we've all seen them. But let's be real. For the modern bar exam, the absolute gold standard is the business records exception. It shows up all the time in any kind of commercial fact pattern, so you have got to know it inside and out. But watch out, because here is a classic trap. Hearsay within hearsay. So take a look at this. The doctor's report itself, yeah, that's probably a valid business record. But that little quote from a bystander that's buried inside the report, that's a whole other layer of hearsay. And that quote needs its very own exception to get in. Every single layer has to be valid on its own. All right, let's totally switch gears and talk about Rule 804. This one is basically the opposite of 803. These exceptions, they only kick in when the person who made the statement, the declarant, is unavailable to testify. Maybe they've passed away, they've asserted a privilege, or they've just vanished. For whatever reason, they can't be in court. Here, we're going to zero in on two really high-stakes exceptions. I mean, these are the kinds of statements that can completely flip a trial on its head, and they carry so much weight because of the dramatic circumstances behind them. The dying declaration is a favorite for trick questions because it is so specific. You have to check 3 boxes. 1, what kind of case is it? This only works in homicide prosecutions or civil cases. 2, what was the declarant's state of mind? They had to believe death was imminent. And 3, what was the statement about? It has to be about the cause of that death. Miss any one of those and it's inadmissible. Then we've got the statement against interest. This one applies when someone who is not a party to the case says something that's really damaging to themselves, and now they're unavailable. The logic is just common sense, right? A reasonable person simply wouldn't admit something that could cost them money or get them in trouble with the law unless it was absolutely true. Okay, let's pivot. We've talked a lot about getting evidence in, but what about tearing the other side's evidence down? It's not just about building your case, it's about dismantling theirs by attacking the credibility of their witnesses. This is the art of impeachment. Impeachment is all about attacking a witness's character for truthfulness, and your most powerful weapon, a prior inconsistent statement. Seriously, nothing shatters a witness's credibility for a jury faster than showing them that they've told 2 different stories at 2 different times. But you can take it even further. Under Federal Rule of Evidence 609, you could actually use a witness's past criminal convictions to suggest they shouldn't be believed right now on the stand. Now, the crucial point here is that there are two totally different standards. If the past conviction was for a crime involving dishonesty, think perjury or fraud, the judge has almost zero choice. That evidence must be admitted. But for any other felony, the judge has to do a balancing test, weighing its impeachment value against the risk of unfairly prejudicing the jury. Next up, we have a foundational requirement that trips up so many people. You can have the most perfect, damning piece of evidence in the world, but you can't use it. Not until you've proven that it's authentic. So authentication is just the process of showing enough evidence to support a finding that the item is what you claim it is. It's a low bar, but it's an absolutely critical one, especially now as we move deeper into an era of digital proof, from emails to AI-generated code. This brings us to probably the most misnamed rule in evidence, the best evidence rule. My advice, just forget that name. Seriously, think of it as the original document rule. All it means is that if you are trying to prove the contents of a document, you have to produce the original document itself. And for the NextGen exam, this is critical when it comes to digital evidence. If a witness is on the stand testifying about the contents of a text message or a photo, the original document rule applies. They can't just describe it. You have to authenticate and produce the original digital item, proving the source of that screenshot or that data log. Okay, now let's tie all of these rules together. We've been deep in the weeds on the what and the how, but now it's time to understand the why. This strategic framework is the key that unlocks the entire subject of evidence. Mental shortcuts are essential for speed on exam day. For the key rule 803 hearsay exceptions, lock in PESPB, present sense impression, excited utterance, state of mind, statements for purposes of medical diagnosis, and business records. And for using character evidence for a non-propensity purpose, the classic is mimic, motive, intent, absence of mistake, identity, and common plan. But to achieve true mastery, to be able to answer those weird curveball questions you've never seen before, you have to go beyond just memorizing acronyms. You have to understand the fundamental principles that govern every single one of these rules. And this is it. This is the foundation of everything. Every single rule of evidence ultimately serves one of these three pillars: ensuring reliability, ensuring fairness, or promoting public policy. So when you're stuck on a question, just ask yourself, which of these goals is this rule trying to achieve? That's your compass. It'll point you to the right answer every time. So remember this, the goal here is to totally transform your thinking. You are not a student memorizing a rule book. You are a strategist developing a real forensic instinct, able to analyze any piece of information and know exactly where it fits in a courtroom. You are now equipped with the advanced rules and the strategic framework to navigate the future of law with authority. Use these rules as your shield and your sword. The bar is yours to take.